Morning.
Good morning.
Pardon me. May it please the court, Jay Goda, along with my colleague Greg Kehoe, on behalf of the petitioners, former directors and officers of Florida Bank Group, and more specifically Robert Rothman and Susan Martinez. I'd like to reserve 5 minutes for rebuttal. In this case, the trial court permitted the plaintiffs to amend their complaint to add a claim for punitive damages based on a conclusory statement of party intent in an expert affidavit that sought to establish what the plaintiff's evidentiary proffer could not establish. If allowed to stand, the procedure that the plaintiffs followed in this case would open the door wide to punitive damages claims in every type of court case, so long as the plaintiff retains an expert to offer a legally deficient opinion that the defendant's conduct satisfies the punitive damages statute. This is the equivalent of offering no evidentiary proffer whatsoever.
Doesn't his opinion go with standard of care? And experts opine on standards of care all the time.
So if you look specifically at paragraph 47 in the McKell affidavit, his statement actually ties to intent, the intent of the parties. And if I can read it to your honor.
Is that necessary though? I mean, intent is not the only thing. Intent can be inferred from all of the allegations.
Intent can be inferred.
You can infer from the allegations and the communications that they had knowledge of some knowledge that they didn't have along.
But in this case, the plaintiffs relied on an expert to infer intent. There was no independent evidence.
Are you arguing that expert testimony is never allowed in 768.72 subsection 1 here?
No, I'm not taking that
Okay, so
extreme.
we do have an expert who appears to be conventional, been banking for 30 years and gives an opinion. Would you agree with me, because you went to law school, I went to law school, because we don't like that. So would you be able to go through this labyrinth of financial minutia? It's beyond the common knowledge of Joe Smith and Susan Smith and the jury box. So it seems to me that's a subject for expert testimony. And I'm not willing to sit here and say that expert testimony is never allowed in that type of hearing. So would you agree with me? It's allowed.
In general, expert testimony may be
Okay,
allowed.
so what's wrong with him rendering opinions? That's why you call him expert in the first place. You don't call him just to say general. You get him to get to talk about his evidence.
Well, in this case, I actually think he was exceeding what he's qualified to testify about.
Well, but you argued so strongly and well in the brief about you gotta prove intentional misconduct and gross negligence. Well, that's the reason they hired him, because he didn't go to financial banks, go get an MBA, so you get Mr. McKell to come and say, I'm reviewing all of this stuff, and this is my conclusion based on that, and experts can run hearsay too. So it seems to me, I understand what you're doing, you're making a great effort, but we can't weigh the sufficiency of evidence yet. Some of our colleagues want us to be able to, but we haven't been told that yet based on the law.
Right, and my response to that, Your Honor, is I recognize the case law that follows the Globe line of cases from the Florida Supreme Court, but our challenge really isn't a sufficiency challenge. Our challenge here is that the affidavit constitutes no evidence. It's not
The trial
evidence.
court relies solely on the affidavit, because the trial court in his oral, when he said, I'm considering all this, I read all this, 2-hour hearing, and then in the order, he expressly states, I've read all of this. I understand the conclusion of the order mentions the affidavit, but are we to sit there and take that one paragraph down and say the judge just simply rely on McKell's testimony only?
In this case, I think the answer to that question is yes, and to understand why my answer to that question is yes, you have to understand the history of how we got to where we got and how the issue was teed up for the trial court judge. So in this case, the plaintiffs filed a motion for leave to assert a punitive damages claim. They cited no evidence whatsoever. That's a record page, appendix 73 through 75. It doesn't mention or describe any evidence. A month later, they filed a memorandum of law. The memorandum of law only cites paragraph 47 in the McKell expert affidavit.
When did they file the depositions and the bank documents and the affidavit?
They filed that at around the same time as their
So we're
memorandum.
not arguing that it was on time.
No, Your Honor. We're not arguing that it was untimely filed. But what we are arguing is that they just dumped the box thousands of pages of depot materials without pinpointing anywhere in those materials where it actually established the statutory requirements to meet the proffer to set forth the punitive damages claim.
Well, it's not a summary judgment motion where under 1.5 you got to identify the evidence that you intend to lie, right?
It's not a summary judgment standard per se, Your
No, it's not
Honor.
a summary judgment motion either, where
No.
it expressly requires the movement to identify the evidence, to put you on notice of what they intend to argue.
I do believe there is a burden there, Your Honor, on the plaintiffs to identify evidence that's being proffered so that it can meet the statutory criteria under the statute. So what happens in this case, Your Honor, is that they submit the affidavit, and the affidavit, the paragraph 47, is the sole statement that satisfies the legal standard under the punitive damages statute. They don't cite any other evidence. So our point here is that just relying on that statement, which we think is legally deficient, could not satisfy the punitive damages standard.
Why is legal deficient? It's legal deficient because an expert's not qualified to opine on intent.
In this case, under these facts, the expert can't testify to the intent of the
Because
party.
is intent necessary? The statute requires, the wrong statute.
It's 768.72.
The personally guilty of intentional misconduct or gross negligence. So an outrageous deviation from the duty of care, given that the standard for the trial court is just a reasonable showing that the standard of punitive damages met, is an outrageous deviation opined about by an expert, something that could give rise to a reasonable showing that there was gross negligence?
No, it isn't. And the reason for that, Your Honor, is because outrageous deviation is taken from a line of case law that has no application here. They're nursing home med-mal cases. This is a breach of fiduciary duty.
Negligence is a duty and a breach of the duty, and there's an outrageous deviation of the standard of care that gives rise to a duty.
Right, but in this instance, under the Estate of Murray line of case law, so Estate of Murray is a second DCA case, an expert can't apply a legal standard to a set of facts. That's well settled principle of law. And when the expert here opines that this conduct that hasn't even specifically been identified in the affidavit, but just generally the conduct constitutes an outrageous deviation from the standard of care, it's no different than reciting the language of the statute.
Well, strikes me you'd have a better case if the judge said he relied extensively or exclusively on the affidavit, but the judge has said that he's looked at all this stuff, which I think Judge Sleep mentioned would include the depositions. So even if we disregarded the expert, that still leaves a lot of other items the trial court considered coming to its conclusion.
There were a lot of other items that the trial court judge considered in this case.
And what you don't like is perhaps the trial judge should have said what it was at.
Well, Your Honor, the record is what the record is now. We will stand on the record and what the order states. However, in this case, the plaintiff specifically relied on that paragraph to tie together the evidence to meet the standard. All the other evidence that was cited, we would submit does not satisfy the standard, the punitive damages standard, which is why they needed to retain an expert to do what their evidence could not do.
Assuming that's true, that none of that gets over the goal line of a reasonable showing. You've made the case that now that reminded me that your argument is not only that the expert cannot opine about the intent of the party, but also that the expert is not permitted to opine in a manner that suggests a legal conclusion or standard, conclusion regarding legal standard. But are those cases like Murray, aren't those cases in the context of a jury? In other words, an expert cannot, before the jury, opine in a way that draws a conclusion on a legal standard. Here, this is pre-trial, and the statute just says a reasonable showing. Why can't the judge say, well, this expert said it was a gross outrageous deviation. To me, that's reasonable showing of gross negligence.
Well,
So, yeah, get to amend.
Well, Your Honor, I would respectfully, I would disagree because under the statute, the trial court judge is required to be the gatekeeper, not an expert. So
So this is not a bench trial. This is a pre-trial motion.
right, under the case law, when reviewing the evidence that's proffered by a plaintiff to move for leave to assert punitive damages
So
claim, the case law says that the trial court judge is required to act as a gatekeeper for that evidence because of the ramifications that could arise if the motion for leave were to be granted, such as financial worth discovery.
I hear you, and maybe I'll look back and see what you cited for that proposition, because you remember it. But another thing that occurs to me is that the legislature said additionally that, I know I'm maybe conflating two things, but that the rules of discovery should be liberally construed to adduce evidence to meet the standard. So in other words, obviously you can't get any of the financial disclosure that they're trying to avoid until the showing is met. But the discovery rules, legislature said, liberally construe them, anything that could lead to evidence to meet this standard. So I know that's not an evidentiary matter, this or a discovery matter, but how should I consider that?
Right, and I still go back to the point that I made before, Your Honor, which is that this really isn't even evidence that will lead the judge to conclude that it is evidence of intent or it is evidence of a gross deviation from the standard of care, because you cannot retain an expert to do that. It's at this stage, it's the judge's job to go through the evidence, and be that depositions, affidavits, excerpts of
What's the difference? I understand, I appreciate the cases you all cited about the impropriety of applying a motion to dismiss, sufficient cause of action, things like that, and relying solely on the allegations. I get all that. So I'm prefacing my question. In a summary judgment motion, we have expert testimony and affidavits all the time. Never objected to, never heard this argument made. This is so much less of a standard. The summary judgment standard just changed its focus. This standard is a reasonable showing. Why can't a judge take the expert testimony and opinions and dissect them the way that he or she should any other evidence?
because I think in this instance, well, I guess I should respond in two ways. The first is I'm not sure the facts of the cases that you have before you where this comes up in summary judgment, but it could be that parties just never objected to this line of testimony.
The ultimate opinion is given to a judge all the time in a hearing setting, being trier of fact or whatever. It's almost demanding in certain cases, given the nature of the case, that requires expert opinion.
So I'm not, Your Honor, I'm not quarreling with an expert opining on the ultimate
You
issue.
saw my good.
No, I think this goes beyond that, is my point. So in this, I'll give you an example. So if an ultimate issue in the case, the defendant's conduct breached the standard of care. That's an ultimate issue in the case that is permissible under the case law. That's the state of Murray from the second TCA. An expert cannot opine. This constitutes gross negligence.
So do you have a case on at a hearing under 768 and 17 subsection 1 that supports what you're arguing?
This case, Your Honor.
Because it seems to me because you're partner in law. I don't know if you argue the law,
I did not know.
but they conflated subsection 1 and subsection 2. Subsection 2 is proof. Because they argue to the judge below. Judge, they have to prove that the defendant personally liable for intentional misconduct and gross negligence. That's wrong. That's conflating subsection 2 with subsection 1. So you're arguing to this court that Judge Farfante can't review the deposition, the affidavits, and can't take an expert's opinion based on his review, given his purported experience in the banking industry, and render an opinion on the issue in this setting.
Just for clarity, I'm not, my position is not that an expert can't render an opinion on an ultimate conclusion in a case or an ultimate issue in a case. A judge could rely on that even at summary judgment. Well, no,
What in paragraph 47 went beyond that? You
well,
just said, it says constitutes outrageous deviation from standard care. Let's say this is a professional malpractice case and you know, MedMal or, you know, an attorney, and you think, so could a bench trial or a jury trial, this shouldn't matter. An expert get on there and say, here's the standard of care in Tampa Bay area for lawyers and this gentleman or lady, blah, 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 or this is the standard of care for, you know, eye surgeons. And that's the most important. It's permissible for the court of the trial fact to go on that, right?
to be clear, for the trier of fact, for an expert to tell the jury that this defendant breached the standard of care, yes, that's entirely permissible, but this is actually, it's nuanced, but it's
Because the
different.
word outrageous.
It is, yes, Your Honor. It's, if you look at the actual statute, okay?
In other words, the trial court, let's say there's a trial court say, okay, well, I'm just gonna ignore the outrageous part and say, at a minimum, this expert is going, there is a standard of care and it was not met. And then I'm going to myself determine from all of the narrative that this affidavit includes and the documents on which it was based, that standard was deviated from in a manner that gives a reasonable showing that it is gross negligence. That's not permissible?
I think in general it could be. I don't think it could be under the facts of this case because I don't think the evidence establishes that, but for the expert's testimony. And it would really be no different than providing evidence of your cause of action in general.
Let me interrupt you for
Sure.
a moment. You've used 17 minutes of your time.
I would like to reserve a couple of minutes, and just to finish your point, providing evidence of your cause of action is different than providing evidence to satisfy the statute for punitive damages, because it's over and above stating the cause of action. So all that evidence, but for the expert, is just evidence of their cause of action. And we know from the Bitline case that we cite in our briefing that you have to do more than just provide evidence of your cause of action. So sure, there can be a breach of the standard of care, but that's their cause of action.
Now you're shunting yourself back into the sufficiency of the evidence, if you don't know we have jurisdiction here, and I'll let you go and talk about.
Okay, we'll pick that back up.
We'll give you 3 minutes.
Okay, thank you, I appreciate it.
Good morning, may it please the court. Isaac Ruiz Cruz on behalf of the respondent. I'd like to start with the estate of Murray case, since there was so much time spent on that with the petitioner. I argued that case to this court. That case, as you can look in the opinion, involved us when we were the plaintiff's attorney. There was a defense expert's deposition, Dr. Desai, and 4 times Dr. Desai's testimony was allowed in that the defendants were not negligent. And this court cited to the town of Palm Beach and other cases for the concept that it is a matter of semantics, but it is a significant matter anyways. An expert can't say negligent, but they can say there's been a deviation from the standard of care. An expert can't say gross negligence, but they can say there was an outrageous deviation from the standard of care. That is a matter of semantics, but it is still a significant matter according to what this court has said in the Murray case. The reason I point that out is because first off, even assuming the torture logic here, and I'll get to that for a jurisdictional purpose, and that is if all we're looking at and accepting all of their arguments is true is this one sentence in our expert's affidavit, their argument is that that sentence is inadmissible and therefore a court can't rely on it. And there's legal problems with that argument as well. But just that issue, is it actually inadmissible? And the answer is no, it's not inadmissible under the Murray case and under those lines of cases. And in fact, time and time again, this would really turn negligence cases on their head. This is what we see in the summary judgment phase. This is what we see in every punitive proffer in every type of negligence case. And why do I mention that? Because the concept that they're asserting here is that an expert cannot testify about an outrageous deviation from the standard of care at a 768.72 hearing. And yet, this court in the Payton case in 1986 found that on directed verdicts, The evidence, the only evidence that was in front of the court was an expert, a medical doctor testifying after review of the records. What? And the quote is in this court's language, that there was an outrageous deviation from the standard of care. It's absolutely acceptable for an expert to characterize deviations from the standard of care. That is different than making a legal conclusion. And this case is really no different than a medical malpractice case or nursing home case or Judge Atkinson, a legal malpractice case. This case involves a number of different counts, but one of them, of course, is what is the conduct of these officers and directors of the bank? And were there breaches of the standard of care of those officers and directors of the bank? And that's what you need expert testimony for, because you're absolutely right, Judge Lee, I did not get an MBA, and nor could I testify, frankly, in the case.
Well,
So you have to
be given the handcuffs we have on us to simply review whether the trial court complied with the procedural requirements. We're still not precluded from reviewing the affidavit for legal sufficiency, are we?
I think you absolutely are.
Well, they're arguing that it's conclusive.
Yes, and if I could go through sort of what that means. The Globe case sets out, and we know from precedent of this court, Your Honor, you and Judge LaRose concurred in recently in the nursing home case, the Edding case, Judge Atkinson's, you were Life Care Centers versus Croft on this point. And that is, since Globe, this court cannot look in cert relief at the sufficiency of the evidence. You can look at see whether or not procedural requirements were met. There's 3 procedural requirements this court has said time and time again. The first is there an amended complaint attached to the motion? Yeah, we have that, no question about it. The second is there a timely written proffer that's filed? Yes, we have that. And the third is, are there affirmative findings by the trial court of a reasonable showing? And yes, we have that. We'll look at that in a minute. If those 3 are met, this court has no certiorari jurisdiction. The argument that, and it's a clever argument, the argument that the petitioner is making is, well, when you look at one, and this is what you have to keep in mind, they're only looking at one sentence of one portion of the proffer, and not just the proffer that was submitted like a banker box was dropped off at the court, the proffer that was actually argued at the 2-hour evidentiary hearing, because that's something that they completely neglect from their briefs. We noted it in ours throughout. There are dozens of instances. If you look at the hearing transcript that's in the record, so at A166 through 239, dozens of instances when I argue from specific portions of the deposition testimony, the exhibits, and the other records that were in the proffer to the court. Why is that significant? Because we're not just looking at one sentence of an expert affidavit and determining whether or not that's sufficient, which this court can't do. But nevertheless, even if that's the inquiry, for example, at A173 to 175 in the hearing transcripts, I quoted directly from emails that these defendants had regarding certain dilution information that needed to be included according to their attorneys in the private placement memorandum to these shareholders. And they refused to include it. And I argued the inference that that shows an intentional act. So this is something else, some other piece of evidence that's being argued to the trial court with respect to intentionality. One of the possible requisites here, either intentional misconduct or gross negligence under 768.72. There was other evidence that was before the court and argued to the court that the court could and did rely on. So another point that I'd like to make, and I know this was mentioned in passing, the court in its order didn't just mention that he read everything in the proffer. The actual affirmative finding, that third requirement, as a procedural requirement under Globe, is paragraph 4 of this order. And if you looked at their petition, it'd be exceedingly misleading, because at page 11 of their petition, they quote this, but then they use an ellipses. And if you look to see, well, what are the 3 dots? What's the missing language? This is the missing language. The court finds that plaintiffs have made a reasonable showing by evidence submitted in the form of the expert affidavit of Gerald McHale Jr., deposition testimony of defendants Rothman, Martinez, and other parties, and other supporting documents and exhibits to ensure that there is a reasonable basis for recovery of punitive damages under 768.72 against defendants Rothman and Martinez. So it isn't just the court in the beginning of his order saying, I reviewed the proffer. This is actually the specific affirmative finding of the court relies on every single one of these items. And under all of the cases, that would suggest that this court does not have certiorari jurisdiction. Probably should be.
So can I ask some clarification? Would you concede that if there was no evidence, that would meet Globe, because it's a procedural requirement that you make some showing, and therefore we have cert jurisdiction?
Exactly. So that's when I said there's 3 requirements. The first being you have to attach the amended complaint. Okay, we have that. That's the Barnador case that didn't do it. The second is, I said there had to be a timely written proffer filed, right? There's a whole line of cases. This court's
So you have a
decision,
written proffer that says nothing. I mean, effectively says nothing that speaks to the issue. Is that, would that satisfy Globe?
a written proffer that effectively says nothing about the issue. That's not this case, but even if it were, Your Honor, I think that's an open question. And the reason I suggest that is because if you look at the Royal Caribbean versus Eidson case out of the 3rd DCA, in that instance, they said that they found the proffer was completely insufficient, and yet they still found that there was no certiorari jurisdiction. So the concept is, once the procedural requirements are met, this court does not have jurisdiction to be able to look and see what's filed and say. And the reason that gets it's that hazy line, and I know we don't like hazy lines, we want to have bright line decisions from our appellate courts. But what we do have as a bright line is, if all you have is allegations or oral representations of counsel, that's not going to cut it. You have to have a written proffer. The only case that the petitioner cites to with respect to this issue is that Tilton case out of the 4th DCA, Tilton versus Roble. And in that case, the first issue is the order just said granted. And then the second thing is, it made it clear, the court said that the trial court did not engage in the type of finding it's supposed to engage in, because there was no evidence, nothing in the record to suggest that the court had actually made a reasonable showing. But then what the court said is, but even if, because in that case, to remind the court, what had been filed was a complaint that had allegations, and this was a defamation per se suit. And then there was an affidavit of the plaintiff himself saying, I didn't steal the money. And of course, the requirement in a defamation per se suit is that the defendant should have known or knew of the falsity of their statements at the time that they made the statements. And an affidavit that just says, I didn't steal money, doesn't show anything about what the defendant knew or should have known. So it didn't meet the standard. And that gets to your point. So in dicta, in the Tilton case,
I lost it. In that case, there was jurisdiction.
in that case, there was jurisdiction, but the court decided it on the order saying the word granted. That's why I said I think it's an open question in that instance.
They introduced an expert opinion that said, based on my expertise, I believe that there is a reasonable basis for recovery of punitive damages because the defendant was personally guilty of intentional misconduct or gross negligence period. That we might have jurisdiction, because that's not really a proper.
So again, and I love these hypotheticals.
It's nothing, or it's not admissible because the expert can't opine.
And that gets to the distinction between 768.72 and 400.0237, right? The legislature has now amended the Nursing Home Act and added the requirement that at this stage, the court look to find admissible evidence, which is Judge Sleet, which you wrote in the Edding case, and Judge Atkinson, what you concurred in the Croft case, that there's a distinction between 768.72. There's no requirement of admissible evidence under 768.72. There is such a requirement in the Nursing Home Act. And why do I point that out? Because the hypothetical that you just gave to me is, what if you have an expert opinion that is on the legal question, because you just recited the language directly from 768.72 and had them make the conclusion, which I don't think that actual conclusion is permissible under a state of Murray. However, at this stage, there still isn't certiorari jurisdiction. Why do I say that? Because the 5th DCA in this court decided this case dozens of times. In the estate of Despain, found that under 768.72, an evidentiary hearing where witnesses or documents are scrutinized under pertinent evidentiary rules is neither mandated nor contemplated by the statute to find that there's a reasonable showing. Why do I say that? Because that means that this type of a hearing, the court is not supposed to be scrutinizing things under the pertinent evidentiary rules. Because that wasn't done in the nursing home cases, the legislature amended the nursing home statute to make it that you have to do it in nursing home cases, but it hasn't been done here. So until that type of a change is done, there is respectfully no certiorari jurisdiction, even though it could be inadmissible. But I'm sorry, but the point is, in this case, however, we don't have an inadmissible opinion even. So we have an inadmissible opinion because the expert didn't say gross negligence, he said outrageous deviation from the standard of care.
So would you agree that the courts of the state, appellate courts of the state, have allowed the type of review that the appellant is inviting in other contexts? In other words, there are cases that grant certiorari, or at least do not, or deny certiorari rather than dismissing for lack of jurisdiction, in cases in which this is pretty much a sufficiency of the evidence, or some sort of failure in the sufficiency of evidence significant enough to say that this was a departure from the central promise of the law.
I think that might be a matter of semantics too, as to whether or not it's really sufficiency of evidence.
But I mean, in other scenarios, would we,
And the scenarios are the ones I just elaborated. If all you have is a complaint where there's an allegation of fraud, then that is something that a court has exercised certiorari jurisdiction on. If all you have is an oral representation of counsel as opposed to a written proffer, then that's something that you have certiorari jurisdiction on. The court in that Tilton case did not say we're exercising certiorari jurisdiction solely because there's nothing before you. But the bigger point is, Your Honor, there is no appellate decision at all in this state ever where an appellate court has exercised certiorari jurisdiction when there is a proffer that consists of depositions, exhibits, and an affidavit of an expert, and a court reviewed all of those and made an affirmative finding based on all of those to find that there was a reasonable showing. Because what they're asking this court to do is take one segment, one sentence out of one of the materials that the court considered, and then apply an evidentiary rule to it. And then their view of that evidentiary rule is, well, that would be inadmissible. Obviously, with these kinds of cases, and I know I looked at my history on this, I've done this 10 times where I've moved to dismiss a cert petition on punitive damages, and every single time the court just kicks the motion to dismiss, and it's heard at this stage. And this court consistently, rather than handle this through a motion to dismiss, handles it through denying a certiorari petition to look at the merits of this. And even though there is no certiorari jurisdiction because there has not been, in this instance, all the procedural requirements have been met, there is no certiorari jurisdiction. But even if
there seems to be possibility of irreparable harm when you start opening up their books during discovery.
so, well, the possibility
It's
of
time to do discovery, find out their net worth. Mr. Hoffman, Moses Skins, whoever they call them, sorry, but.
no question.
Team, whatever that.
No question, Judge Sleet. However, and that is absolutely what the Florida Supreme Court said in the Globe case. There is that
That's
right
why
to
we
privacy.
take it on cert, because of the potential of irreparable harm of being subject to a punitive damage verdict.
Respectfully, the only way this court has certiorari jurisdiction is if the procedural requirement has not been met.
you would agree that is a deviation from the normal certiorari jurisdictional review. As Judge Sleet is
Absolutely.
suggesting, normally we take, we focus on whether it is prejudice that will last the duration of the litigation and be removable on direct appeal. I'm going to take direct appeal.
Exactly.
So Globe is a deviation.
It is, but one that this court.
That's what I was getting at. Is
compelled
that
to
Are there
follow.
other scenarios, and since we're talking about this, why? Why should we deviate in this milieu from the normal certiorari standard?
Well-
That in which jurisdiction is met based on the harm, and then we deny or grant based on the substantive standard of whether it's a established law from which the trial will be.
Two things. So one is this court and this panel has no power to change certiorari jurisdiction when the Florida Supreme Court has established what that certiorari jurisdiction is. However, even if hypothetically that was something that could be carved out, even though the Supreme Court has directly spoken, and other panels of this court have also directly spoken, and both Judge Sleet and Judge Atkinson in prior opinions, I think you've either concurred in or written, that this court has no certiorari jurisdiction to review the sufficiency of the evidence. But even if we were to look at that, keep in mind, and this wasn't cited because this isn't part of the briefs, obviously, but Judge Atkinson, you asked about the fact the rule also discusses liberal discovery in the rule for amendment. Well, this court in Burr versus Norris, it's an older case, I think from 1986, wrote that on punitive damages amendment, there should be the liberal rule, that classic rule of liberal amendment of pleadings, even with respect to punitive damages. The point is, this is a careful balancing act.
Why the legislature took care of that question, and it doesn't seem very liberal to me. We're sitting here arguing.
I don't disagree.
You have to, in order to amend, you have to jump the hoops.
You have to jump through hoops, and those hoops have been set out, and in some statutes like 400.
But I have to just clarify, liberality demanded by the legislature is in discovery for the purpose of determining whether there's a reasonable basis, for the purpose of determining whether there should be legitimate.
That's correct. But with respect to you, getting back to your question about certiorari jurisdiction in this instance, when we're dealing with the amendment of pleadings, which is what's going on, there generally would not be certiorari jurisdiction in that instance, but for the fact that there's this possibility of irreparable harm.
I see.
Yeah.
20 minutes isn't a long time, so let me get back to the merits. Can you say with confidence that you would have made a reasonable showing in this case absent the affidavit?
First off, that's not really the issue that's appropriate for this court to get into, but even if it was,
Humor.
I think we did.
Well, isn't it appropriate if we decide that affidavit was inadmissible and there is no, well, go ahead.
Well, first off, you would be deciding that sentence of that affidavit is inadmissible. And
But
the
it's not my question, Judge Sleet.
I understand, but Judge Sleet, first off, the affidavit is more than one sentence. It goes from RA 49 to RA 66, and it goes through what are all breaches of the standard of care in detail. And in fact, what's more is if you look at the affidavit, you're led to have kind of the belief this is just a conclusory document. But every single one of the statements has a footnote to the page and line of either the deposition or the exhibit that it's relying on, that Mr. McHale was relying on in reaching his opinions. Moreover, not only did I argue at the hearing from these depositions, this was by Zoom because it was during the pandemic. We used the screen share function, and you can see this in the hearing transcript. For example, with respect to A192, I put exhibits 87 and 96 to Susan Martinez's deposition in front of the court and argued extensively from them. So I would suggest that there is ample evidence before the court, independent of this affidavit, to establish an outrageous deviation from the standard of care. But I want to get to your point, Judge Lee, because there's something significant there. This court should not abandon take the invitation that the petitioners have asked this court to do and suddenly not allow experts to testify about characterizations of deviations from the standard of care. That has been done in hundreds of cases I know that I've been involved in. I don't know how many other particular parties have been involved in, where you have experts that come in and talk about breaches of the standard of care and talk about characterization of that. If we didn't, then you know what would happen at summary judgment? There'd be a motion for summary judgment saying, well, you have nothing to show that there was an outrageous deviation from the standard of care, and it cites the Payton case. So it's one of those, you're damned if you do and you're damned if you don't. This court has already accepted the proposition that an expert can testify about deviations from the standard of care and characterize those deviations from the standard of care. And that's exactly what our experience is.
What if we agree with the appellant about the inadmissibility of the opinion regarding standard of care? Could the expert have opined as he did on the intent of the defendant?
Again, and two parts to that. One is you don't have jurisdiction to do it. But even if somehow we put a hypothetical hat on and you did have jurisdiction to try to look at this, that case that they cited to, I think it's Luis versus State, is the criminal case. And the criminal issue that was involved there was that issue of intent. The issue here is gross negligence. And how does our law define gross negligence?
Misconduct.
Or gross negligence. And if we're operating under
misconduct, if we agree with their argument regarding that gross negligence,
Sure.
Intentional misconduct.
experts are, there's a divide even in the criminal cases. And that's what I was getting to in Luis versus State, about whether an expert can actually, in that case, they had a drug expert come in and talk about the intent to actually sell and distribute the drug. And the court said there's a divide in the circuits. Some DCAs allow it and some DCAs don't. In this instance, the issue would be, would you be allowed to have an expert come in and say that their conduct was intentional? There's cases that allow experts to talk about inferences from the evidence. And we could argue inferences. And I did argue inferences. I argued that it was clearly intentional because the undisputed evidence in this case is that these documents were not given to my clients, but they were given to outside investors and they were given to the other classes of shareholders. So it's something that could be inferred from what's there, that there's intent. But even if we were just looking at just that specific, Judge Atkinson, to get to your point is, if this court found the evidentiary rules do apply, and we're going to look at just this one sentence, and we kick this one sentence and ignore the fact that you may not have jurisdiction, we're going to look at it anyways. Our argument is that even in that instance, which we don't have here, that hypothetical, I don't think certiorari relief lies. Whether or not, if the Florida Supreme Court changes the rules of appellate procedure and adds it to the non-final orders that can be appealed, that would be potentially a different story, because then you absolutely would be engaged in some sort of review about the sufficiency. And you may say, well, this one sentence is going to be kicked. Is the rest of it enough? But respectfully, that is not at all the review that this court is allowed to do, and not at all the review this court has ever in its precedent allowed by certiorari.
With that, you would have to wrap it up.
Thank you, Mr. Lewis.
You. 3 minutes.
3 minutes. I remember.
Have at it.
Okay, so I'm going to try to address more than 3 points in 3 minutes, and I'll do my best. But the first point and the most critical was that I heard the representation from plaintiff's counsel that they could offer an affidavit from an expert that simply recites the statutory standard, submit it to the judge, and that qualifies as an evidentiary proffer to move for leave to amend and then receive an amendment.
Or it complies with the procedures.
The procedures, right, as an evidentiary proffer. Right, and then that this court would be precluded from quashing that order. I disagree with that vehemently because
But that still feeds into, in other words, you can make that distinction and still agree that Globe is a very stringent jurisdictional standard, and because you would characterize that as a failure to comply with procedures.
that's right. And I also think that a failure that providing an expert to opine on the legal standard as a substitute for evidence is a procedural error. It's akin to no evidence whatsoever, which I wanted to bring the court's attention to the long line of cases that we cite after Globe, including from this court, the White case that was decided in 2021. And in that case, the court determined that the trial court failed to apply the correct evidentiary standard because all that was offered at that hearing was the representations of the plaintiff's attorney. Our argument is that this is really no different than that. They're just hiring an expert to do the same thing that an attorney would do at the hearing, which is recite the standard to assert a punitive damages claim. That's what we have here. And I'll refer you to the hearing transcript because plaintiff's counsel had mentioned they went through all of this evidence at the hearing. But what's critical here is how they sum up the evidence. And if you look at Appendix 156, this is quoting plaintiff's counsel. So in the second DCA, an expert's testimony with respect to breaches of the standard of care, and then ultimately characterizing it as outrageous, is sufficient on directed verdict for punitive damages. And as we'll look at the proffer, Your Honor, we have exactly that. We have an expert that has reviewed the records and goes through all that and ultimately opines that there's been an outrageous deviation from the acceptable conduct. And then again, just relying on the expert. And this is at record at Appendix 241. What is necessary for grossly negligent conduct in this district? It's outrageous deviations from the standard of care. We have an expert affidavit with respect to that. Our position is that they do cite all this evidence, but what they're really doing is packaging it up in a way that they present it through an expert to make it sound more credible in order to lend credence that there actually is an evidentiary proffer that satisfies the statute. And that is a procedural error because you need evidence. And I would cite the Tilton case from the 4th DCA, which is from 2016. The actual issue in that case was an affidavit, and it was up on cert, is an actual affidavit from the plaintiff. It was a defamation per se case, where what was at issue was the defendant's knowledge. Knowledge is also at issue in this case. There's intent. And in that case, the plaintiff said it's a defamation per se case. So the plaintiff said, no, I didn't say that. So the defendant, the knowledge of falsity of the statement was at issue. The plaintiff submitted an affidavit. The 4th district was able to look at that affidavit and conclude from that affidavit that that wasn't a sufficient proffer under the cause of action that was submitted and quash the order. That was a punitive damages review, and I'd urge the court to take a look at that case because it's strikingly similar to the facts of this case where the order was quashed and it wasn't improper to review it in that manner. Another point that I just want to mention,
quickly.
there is a rule amendment to the non-final 9.1. I'm not sure if the court is familiar with that, but the Florida Supreme Court actually proposed the rule amendment to the Rules Committee and directed them to implement the rule. It was argued in August. My belief is that the rule change is imminent. That I'd ask the court to quash the order.
Thank you. Thank you both. Very well argued. We are going to take a 10-minute break and we'll be back to conclude our docket.
All right. court will remain in recess for the following 10 minutes.